Since 1983, FAME has helped business and education work for Maine. Contact the Authority, the Finance Authority of Maine.
Welcome. This is our Afterthoughts segment where we keep our guests around for a little extra discussion after the show. This is seen only on the web, and with us today we're talking about labor law issues that businesses need to be paying attention to for 2011. Anne-Marie Storey, partner with Rudman Winchell in Bangor, has been kind enough to come back on the show and help us keep our act together here. So she's back, and we're going to ask you a little more about some of these things we talked about. We talked about three things. We talked about the Medical Marijuana Act, the GINA, the Genetic Information Nondiscrimination Act, and changes to the federal Family and Medical Leave Act. I'm going to go start with that one, the Family and Medical Leave, again, because I still get confused, and I don't know if employers do, about how do we know which law governs, federal versus state? So just what's the deciding?
It can be very confusing.
Okay.
It's mostly driven by the number of employees you have.
Okay.
Any employer who has 15 or more employees is subject to state FMLA.
15 or more.
If they have fewer than 15, they are not subject to any of the FMLA laws.
State or federal.
State or federal.
Okay.
So up to 15, none.
Mm-hmm.
From 15 to 49, they're covered by state law.
Okay.
Once the employer has 50 or more within a 75-mile radius, and of course there are exceptions to everything,
Oh, God, I know that.
then they are covered by federal law as well. And that's as well. That's not in lieu of state. So an employer who has 50 or more employees and meets that definition will be covered by state and federal.
Okay, so if I have more than 50 employees within my 75-mile radius, I'm covered by both, state and federal, but and if one is more restrictive than the other, that's the one that governs. Is that correct?
The one that gives the employee the most rights is the one that governs.
That's what I meant to say.
And so you get some very interesting problems because, for instance, federal does not provide coverage for domestic partners, but state does. And so an employee's entitlement to leave during the course of a year is driven by the order in which requests for leave are made. So let me explain that further. If I were to make a request at the beginning of my leave year and the amount of time under state and federal is different, of course. Yeah. I get 10 weeks of leave in a 2-year period under state law, and I get 12 weeks of leave in a 1-year period under federal law. So if as of January 3rd, I make a request for time off for a serious health condition of a domestic partner, I would be entitled to that time. I'm entitled to 10 weeks in a 2-year period. So let's say I take my whole 10 weeks and I come back to work. And then in May, I want to have a medical procedure of my own. And I need 6 weeks to do that. I've already used 10 of my weeks. So I only get 2 more weeks under federal law because I only get no, see, now I've already gotten it mixed up.
I'm glad.
I've used my 10 weeks under state, but because federal doesn't cover domestic partners, I still have 12 weeks of federal law to use. But if the situation were reversed and I first used something that's covered under state and federal, I would not get the remaining 12 weeks. I would only get what was left, which would be 2 weeks.
Okay. Remember we started when I was doing the intro, I said these are nightmarish. That's one of the nightmares. It's I can never quite figure that out.
It's great fun, though. It's a puzzle.
It's great fun. You're sick. That's wrong. That is so wrong. Okay, let's talk about marijuana again. Just because I want to make sure people are clear on that one, too. Working under the influence of marijuana, I still don't have to allow an employee to do that, do
That's
I?
right. You do not.
Federal or state or any which way, right?
It's a little bit similar to Maine's.
But how can I do that if it's like wouldn't ADA kick in?
Well, that's the problem.
You're denying me my medication.
You then have to talk about reasonable accommodation.
Okay.
But the law specifically says that it does not require me to allow an employee to work while under the influence of marijuana.
Okay.
And so that's my out for that provision. Ordinarily, yes,
that's state,
you would have to make that. That's right. That's state. Ordinarily, you would have to make reasonable accommodation for someone who was on a medication because of a disability, if an accommodation was possible. But we say, yes, that's state. Of course, under federal law, it's illegal completely.
Right.
So
that's another question, I guess, is do you anticipate there are going to be some tests of this in the workplace? I mean, obviously, a lot of folks are trying to test that law, I guess. whether they can be legal or not, and you think that's going to be impacting employers now?
I mean, I wouldn't be surprised if it were, just for someone to test the limits of what the state law is going to allow them to do. But on the other hand,
well, I mean, would they be testing it federal though, bringing in, suing the employer perhaps instead of just the person, or to really sue the employer to draw attention to it?
Although, this is all speculation now, but the more an individual throws this in the face of the federal prosecutors, maybe the more likely they are to get themselves in trouble than the employer, because they are engaging in behavior that's still illegal under federal law, as I understand it. I'm no criminal attorney, so I'm speaking only from an employment perspective.
That one just seems like it's the right thing, depending on which side you are, it's the right thing at the right time, and it's state law, and it's all there, but man, it's really, it would make me really nervous as a major employer, if I were a major employer, thinking, I feel like I'd be a sitting duck saying, not from the person perhaps using it, who's using it for their medical purposes, but from an interest group that wants to test that, perhaps.
Well, and not only that, but employers who have people who do safety-sensitive work. I mean, suppose I use machinery or I drive.
But that gets back to reasonable accommodation, though, too, right?
Yes, and it's going to raise all kinds of questions about, nothing about this is going to be easy. I mean, it's just, even to the point of if an employee says, okay, I'll only use it when I'm off hours, well, when does it leave your system? And how am I as an employer supposed to know whether when you come into work at 7 o'clock in the morning, are you still under the influence or are you not?
Right. And if you have a testing policy, that may impact that too, drug testing? Or is that it doesn't only apply for hiring and?
They don't. They can apply randomly, or they can apply in the case of an accident. Now, of course, you have to have the policy pre-approved, and you can't just all of a sudden create. So that's one thing employers should not do, is just go out and all of a sudden, just write some kind of testing policy and say, this is what we're going to do now. You have to go through the proper steps to have that all approved.
Right. Oh, man. It is kind of fun, you're right, actually, in terms of the puzzle part of it, but HR people, I'm sure, don't think it's fun. They just got to hate
I'm sure they don't, especially when you're still in the testing phase and nobody really knows how a lot of this is going to play out.
And somebody's going to be the test.
Someone's going to be the test.
Somebody's going to be the test, and you hope it's not your company.
That's right.
And the last one then with GINA, genetic information, non-discrimination. Anything else there we need to know about? I mean, you covered that pretty well. Once again, it's one of those things, just be careful what you're asking for and make sure that you've got the request, that you've got the language in the request before you send it out.
And, one big red flag, if an employer out there doesn't know what GINA means and he's hearing this for the first time, they need to really educate themselves and become aware of it, because one area that it does impact significantly are wellness programs. And I'm a big advocate of wellness programs. I think there are a lot of very positive things about them, but there are a lot of pitfalls in wellness programs.
Like what?
For good intending employers, and GINA is one of those.
But you're not going to be collecting genetic information as part of a wellness. I mean, blood pressures and cholesterols.
You might get it because of the health assessment that employees are often asked to fill out as part of a wellness program.
They may voluntarily supply that information.
Either that, or a lot of those health assessment questionnaires have questions about medical history. And if you have a doctor do a health assessment, part of any physical is a medical history, because that's how they figure out, what your risks are. And so it's there are some very specific provisions about permission from an employee to do that, signed waivers, things like that.
And then the other thing, not to be too cynical, although I am pretty cynical these days. Of course, we have good lawyers on this side of the fence, working with employers and companies to make sure that they know their rights, and with employees too, make sure they know what's really the right. My guess is there's some attorneys on the other side of the fence that are looking at this stuff going, there's some money to be made here too. If you find the right, violation, if you look for that thing. That part was what scares people, I think, employers out there, because that could happen.
Oh, absolutely.
Sure.
Yes.
Okay. We're going to wrap it right there. Thank you again for coming around. We'll have you back around as things keep changing, because they don't get less, they keep getting more.
No, every day it seems like.
And even if they don't increase, the interpretations change.
Yes, absolutely.
Great. Thanks again.
Thank you.
Okay, thank you all.